Right, let's get started then. Let's get started. Welcome to the second instalment of Liaising with Legals. My name is Daniel Edmondson. I'm the National Account Manager from AdviceWise, and we're going to be going through a session today with a panel of specialist legal providers. Hopefully by the end of the session, you'll be able to take away some best practice, a better understanding, and being able to understand, the different levels of considerations when it comes to putting security on. So you'll be able to think of it from the lender's perspective, obviously from the customer's perspective, from your perspective. Ultimately, the goal is to help you manage expectations, right, and drive great customer outcomes. So we'll go through the session agenda in a little bit more detail with introductions shortly. But just in terms of housekeeping, hopefully we're not new to Zoom meetings or virtual meetings anymore. But mics and cameras, just be conscious to have your microphones off while somebody else is speaking. Cameras, you're welcome to turn your cameras on, but if you have a limited internet signal at home, it often helps with bandwidth and the viewing experience. That said, we do encourage you to engage with us. We want this to be sort of more workshop than webinar. We don't just want to speak to you for the next 45 minutes. The beauty of these sessions in the past has been where you guys can shout up about your difficult cases, utilize the chat box, and we can have a bit of a to and fro, a backwards and forwards, and we can share best practice with some of your peers, some of the delegates on the call with us today. This session has been recorded, so you can watch it back retrospectively. We will follow up with an email probably in the next day or two with a recording link alongside your CPD certificate. So don't worry about chasing us for that after the session. We'll follow up with the usual comms. If you think this session will be useful to pass on to a colleague or a friend, a peer, please do send them on the session recording as well. Again, we want to share best practice and drive excellent customer outcomes. If you haven't already seen the chat box, if you hover your cursor to the bottom of your screen, the more icon will open the chat box. I've included a few links there, one to our partner and the speaker sites, and two, some register links and demo links and things from AdviceWise's perspective as well. So please do have a little nosy and have that open throughout the session. Same with the speakers. If you can have that open as well, we can follow through with some of the questions and engagement from the delegates. Before I do pass you over and introduce the speakers on the call today, I just want to give you a loose, quick update in terms of market conditions and then any other events to be aware of that you can take value from. So in terms of market conditions, the lowest rate in the market as we speak right now, it's in keeping that I'm updating through a sourcing system, but 5.45%, and that comes from the interest servicing plan. So just currently have the top spot when it comes to strictly cheapest rate. However, we are seeing some increases this month. We've already had 3 increases and we're on the 5th of the month, and I do have a few more in the pipeline. So the takeaway message from that is, rates do seem to be increasing. Take advantage of any KFI validity periods or anything like that. I would ensure that we're securing rates whilst we can. That said, inflation is, I'm going to say, an all-time low for the last couple of years. It's currently 3.3% as of the last update in May. And as of this morning, the Bank of England updates it at 2.3%. So it's so close to that 2% target that we've been trying to achieve since October 2022. A date for the diary, though, for you advisors, 19th of June is when the next inflation report comes out. And the day after, the 20th of June, is when the base rate announcement comes out. So we've been 5.25% for a few periods now. Hopefully, some people might be skeptical, but we might have a reduction in that, the first reduction in some time from June onwards. So let's look out for that. I do wanted to highlight, we've had quite a few queries on our help desk in and around some of the product innovations. So it's great to see product innovations from our lender partners, but it's been hard for advisors to understand and differentiate between the PTLM style products, the products that require mandatory payments for later life, and also the interest servicing products. The reason I raise this as an important point is because those products are often top of sourcing and appear quite well when it comes to interest rate. And it's important to understand what comes with them, what consumer safeguards. So it's the interest servicing plans that comes with the safeguards that we know and love, lifetime tenure, no income and affordability assessment, etc. So they really are some quite flexible plans, and there's more innovation coming in that space. So if you're not too familiar, want to know more information, pick up with us, our help desk, our experts, or pick up with the lenders directly. Their BDMs will happily come out, have a coffee with you and talk you through that as well. When it comes to rate changes, as I say, 3 already. We had 25 changes in May, and quite a heavy amount of them were increases as well. When it comes to advisor feedback, AdviseWise is built on advisor feedback. We're built for advisors by advisors. So please do pick up with me offline directly. We can book a one-to-one demo. Tell me what you like, you dislike, good, bad, and indifferent. All the feedback is welcome. And then lastly, when it comes to any future events, we're doing a webinar with Loughborough early in July, 18th of July, date for your diary. We'll send out the links soon for that. LV are doing a webinar next week on Tuesday. It's called Economy, Property and Later Life Lending. And then we're looking at arranging a care-focused webinar. So what happens when the money runs out? What considerations do you need to have as an advisor when you've got a client that's considering care or paying for care? That's all from AdviseWise. Appreciate that's a whistle-stop tour. To formally introduce the speakers to the session, we have Matt Taylor, Business Development Director from Equilaw, Peter Barton, Managing Director from Barton Law, Adam Carnall, Director of Partnerships from Forever Legal, Rachael Brandon, Director at Boyd Legal, and we also have David Burns, Operations Manager at Enact. So we've got a representation from your client's perspective in England and Scotland. So we have Rachael from the Scottish perspective, and then we also have the lender's consideration, the lender's representation with Dave Burns from Enact. So that, again, going back to the original learning objectives, gives you an advisor the opportunity to understand the different perspectives to ultimately help you manage expectations. So let's pass over to each individual speaker just for a quick introduction, a quick overview, and then we'll get going with the actual core session, talking through some difficult cases. Again, whilst the guys are speaking, please utilize the chat box for any cases you would like discussing live on session, and we will go from there. But first and foremost, over to Matt from Equilaw, please, mate, just for a quick intro.
Morning, everyone. Cheers, Dan. Yeah, Matt Taylor, Business Development Director at Equilaw. We're one of the specialist law firms that operate in the ER world and later life lending space. Cover all of England and Wales. Been around for quite a while now, so not a lot we haven't seen. Probably seen some slightly green shoots in terms of the market turning around and being a little bit busier than what we've seen. I guess the guys will chip in and probably concur on that point, but also point out some challenges and things we're seeing crop up at the moment. So yeah, it'd be good to have a chat through some ways we can work together and hopefully make the journey quicker, easier, and better for everyone involved.
Fabulous. Thanks, Matt. Straight over to Peter.
Thanks, Daniel. Peter Barton, Managing Director of Barton Law. Very much like Matt and Echo, been around since creation day. So grown up with the lifetime mortgage sector. Green shoots. I think 1 week it's green shoots, the next day it's arid. I think from our side, we're seeing great service by David and his team, which I'm always delighted with. One thing that we're doing at Barton Law, which I'm sure the rest are doing, because we all operate as specialists, probably I hate to use the word, slightly better way than the high street solicitors, is that obviously we're pinpointing potential problems. So one thing that we're doing here at the moment is anything which might cause delays at the land registry, rather than taking up the time of the lender's solicitors, we're just dealing with them. So we're using the mortgage offer that comes out to expedite it. So actually, by the time we get the signed papers back from the clients, they'll, if not back from the land registry, on the verge of being back from the land registry. So as Daniel said, in a time where rates are going up, we don't want the offer to expire. So we're chucking that into the land registry, which goes back to the whole point, as I always harp on about, of I was working with you all as advisors to identify problems before you write the application, so that clients can be ready to supply things rather than going back to you and moaning, saying, why is Matt or why is Adam asking for these things? There's a logic behind it. So that's it from the West Country.
Thank you very much. From the West Country, Peter. Adam, please, from Forever.
Hi, morning everyone. Thanks for having us along. Yeah, I'm Adam Carnall, Director of Partnerships at Forever Legal. I suppose we're one of the relatively new kids on the block. Been trading about 4 or 5 years now, from memory. Yeah, like Matt, Peter, and Rachael, we operate in the specialist later life sector. So we do equity release. Alongside that, we also do residential mortgages, so people taking or looking at alternatives to equity release, such as retirement interest only, maybe high street lenders, building society lenders as an alternative to equity release or lifetime mortgage. We operate in that space as well, and we also do the estate planning side as well. So we can look at wills, LPAs. So we see ourselves as a sort of later life lending solicitor. So yeah, that's kind of where we operate. But yeah, we're here to promote the use of specialists. If people are giving specialist advice in this sector, which it clearly is, then ideally you should employ the services of a specialist solicitor, because those in the high street who don't specialize in it will generally tend to cause delays in our experience. I'm sure Dave can concur with that. But yeah, great to have me along, and look forward to the session. Thanks.
Cheers, Adam. Yeah, as mentioned, straight over to Dave if I can for an intro, mate.
Thanks, Dan. Good morning, everyone. Yeah, I'm the operations manager for equity release at Enact. My focus and the focus of Enact as a business really is on swift and repeatable solutions for volume processing of remortgage and purchase transactions. We are the UK's largest conveyancer in terms of transaction numbers. And a large proportion of what we do is equity release, so it's a very important area for us. In terms of the market at the moment, some of the guys have touched on this. We're seeing fantastic turnaround times on some cases, and then a small section of cases where there do appear to be difficulties, as Peter mentioned, complex cases and kind of customer appetite to complete with the rates available at the moment. So a game of two halves.
Yeah, there's definitely some challenges at the moment. And one of the discussion points actually was talking around the different demographics and the different types of cases we're experiencing at the moment. So I'm sure we'll come on to that in good time. Last but not least, our Scottish representative, Rachael from Boyd Legal.
Hi, I'm a director at Boyd Legal. I head up both the estate planning private client department and the equity release department. The equity release department is a later life lending department, basically. So we specialise in equity release, but also do REOs. And the team can also liaise with our conveyancing department if you've got purchases to do along with your equity release. We do cover the whole of Scotland. We've got offices in Edinburgh and Kirkcaldy, and we have other office facilities in Glasgow, Aberdeen, Inverness, Perth, and Dundee. We've got over 10 years experience in this area. I have a dedicated team that purely deals with equity release and REOs. So it is useful to use a specialist solicitor in this area, because we can foresee any issues or potential issues which could cause delays. And I'm always conscious that if you go to a mainstream, like a high street solicitor, the file will just get put with the conveyancing workload, and they don't anticipate how long an equity release will actually take, especially if there's challenges, because you've got to satisfy the lender solicitor as well, which can be quite time consuming depending on what the issue is. We obviously work with brokers closely, so if you've got any complicated cases at the outset that you want advice on, we can offer that service to download a title, have a look at how title's held, for example, in case you wondered if it's in joint names or a sole name. Yeah, so that's Boyd Legal in Scotland.
Thank you very much, Rachael. And now moving on to the main section, but just before I do, a reminder to everybody. So we'll just shout out some names. So we've got Dave, Connor, Alan, Greg, anybody that wants to input any chat, any conversations, any questions, please utilize the chat box or unmute yourself. But kind of different to what we've done in the past, where we're calling on you guys as delegates to discuss your hard to place cases, I do want to position that back to the speakers to talk through perhaps a case that they remember from the last week or two, the last month, where they've perhaps had a great customer outcome that was a little bit more technical. So in the same order as the introductions, we'll go to Matt first, just to kind of put a spotlight on them, and just to sort of shout about a scenario with probably some salient learning points, what you can take as advisors away. So Matt, over to you, mate, if I can.
Yeah, thanks, Dan. I did send this this question around the teams actually, and probably could have filled half an hour of chatting through some fiddly cases that we've managed to get over the line. Probably one that stood out the most was a matrimonial transfer file that we were actually instructed on in 2022. So it'd been in the system for well, now on 18, 19 months, which was challenging for everyone. Sort of first issue, I guess, would have been the husband who was coming off the title, not overly keen at doing the kind of things we were asking them to do, and what the lender solicitors were asking them to do. So there was a challenge of getting that side of the transaction satisfied. There was a query on some unregistered land as well, which ultimately probably didn't impact on valuation too much, but there was a slither of land that needed sorting out. It was incorrectly registered the first time round, so there's a possessory title problem as well. Time frame on the offer, probably onto the third, fourth, maybe even the fifth offer. It was one of the lenders who had a slightly longer offer period, so rates were changing and generally going up. Probably the learnings were, as always, if you've got a fiddly kind of case, or it might sound like it's going to be fiddly, triaging the title as early as possible with your client solicitor is really, really useful, and not just the main title, cross-referencing that to potentially the valuation and other bits of land and things that might come into play, involving the stakeholders that are going to need to do things during the process, particularly on these matrimonial files, the spouse or partner who's coming off. And really trying to get them on board with what they need to do and the paperwork that needs to come back from their solicitors, and a collaborative approach as much as we can do between advisor, client solicitor, lender solicitor. We pretty much had to beg the lender solicitor to give us an extension to take a view on the possessory title issue. Advisor was doing the same from their end, and we finally got the case over the line just before the last offer was due to expire. So great result for everyone. Probably didn't make any money off of it because, like I say, it was in the system for 18, 19 months. But the client was happy and was relieved that they finally paid their horrible ex-husband off. So that was the one that stood out for us.
Brilliant. Thanks, Matt. It's great to see a good customer outcome at the end of all of that pain and time spent. Over to Peter, please, if we could just go through a memorable case along with some probably salient points that people can take away, that would be really useful.
Okay, I've got two, Daniel, so apologies. Very quick ones, I promise. First one, I think, is probably a learning point for me more than anybody. Also for the advisors to try and give us as much information as possible. So scenario is a lady of a certain nationality that we'd all be concerned about, currently embroiled in a war against Ukraine. So I won't mention the nationality, but hopefully we can all figure that out. It all seemed, lots of circumstances led it to be very suspicious that we had a very pushy child. The money was being taken on a quite substantial London property, mortgage-free, taking £350,000 to repay a similarly nationalitied relative. So instantly, and that's all the information that we had. It didn't help that the lady was deaf, couldn't read or speak English, which meant that we had to have a translator and a solicitor doing the visit. At that meeting, we asked the client for the purposes, and she was adamant it was for home improvements and for general living, as opposed to what was on our crib sheet. I had nightmares of a missile heading with the Barton logo on. So yes, I then, was on the verge of binning the case, but then dug a little deeper. Lo and behold, the financial advisor produced to me properly drawn up loan agreements with this relative. And I spoke with our regulators, who gave me, I won't say telling off, but a bit of a reality check, and said, look, just because they're of a certain nationality, unless they appear on the sanctions list, you've got all the evidence that you need. So please do crack on. So, and the case is completed. I've not heard or seen of any missiles with the Barton logo on, which is a relief. But at one stage I did have this image of having a knock on the door from MI6 or something like that. So for me, it's a plea to everybody. If we have cases that, if you step back and think it may be a cause of concern, please do give me as much information. And the minute I asked for the extra information, it was all forthcoming, but it caused me a few sleepless nights. Second case, very quickly, I've recently inherited a case, been rumbling on for 15 months. Client has a restriction on the deeds that the neighbours have to sign off if they're ever going to take a charge. It was incorrectly, and David will give a knowing smile in a second. This is one of his. It's a very badly or oddly worded restriction. They went to see the solicitors that kind of approved all of this, and they were adamant, because they're not old school, but they didn't want to admit they'd done it wrong. They were adamant that it was correct. So it's been going to and fro. Add to the fact that the wife has cancer, always had cancer. The purpose of the loan was to help her have a quality of life before she passes, because it's terminal. They came through to me, thank goodness, to the recommendation of a financial advisor. We've checked it. We 100% support David's, understanding of the case is completely correct. I've got the client speaking with the neighbours who are quite happy to vary it. The case will go through, and we should be done, I would say, early July, to help the lady's quality of life. So again, it's, it just highlights the importance of, specialist solicitors in this. Enact were 100% correct on their interpretation. When it came through to one of the specialists, we agreed to see exactly what they're getting at, and it will go through. We will turn it around within 4 or 5 weeks after 15 months of rumbling on.
Amazing. Thank you, Peter. Very detailed, and thank you for adding the extra one on there too. Really appreciated. Adam, from your perspective, please, any particular wins you want to shout about this month?
Yeah, well, we've got a case going on at the moment, which is probably not that peculiar at the moment. So a bit of a background: the house was originally in her mother's name. It was the family's home. She'd been divorced a number of years. Her oldest son asked mum to lend some money so that he could buy some buy-to-let as investments. She allowed him to take out a mortgage on the house, but he had to transfer his ownership to his name. But she trusted him. She goes, "Yeah, my son, yeah, you crack on." He got married, had 3 kids, then gets divorced. So then they become a court order. So 3 of the properties has to be sold and given to his wife. The other 2 are to remain with him. And what they're trying to do now is they want to, so there's 200 grand mortgage on the house worth 700,000. Mum is trying to raise equity release to pay off the mortgage so the house can be reverted back to her name. That has to be treated as a purchase, and it's not an Enact case, which Dave will be pleased about. But because it's been done for 200,000, it's being treated as an undervalued transaction, which only a couple of lenders will do. So we're going through all that. We're finally getting it over the line, and then it comes to light that there's a piece of land which is unregistered, which the lender's got a problem with. So again, we need to do possessory title on that. So it's a really complex case. We've got it over the line. It has taken a number of months, but the key to it, all of it, has been communication. So communication with us, with the client, with the son, with the third-party solicitors, because obviously the ex-wife has got a solicitor in the background because there's a court order in there. Lots of communication with the lender and the lender solicitor. So there've been lots of joint calls, but it's been keeping that communication and keeping everybody on side and basically saying, look, this isn't a straightforward case, as you can probably tell. This is the timelines. This is what needs to be happen, and being very clear and very precise about that, and having an assigned case owner. It's been dealt with as a purchase as well, which means it's got an added layer of complexity. But it's about being very clear up front and making sure that everybody knows what they're doing. This is the information we need, and doing it that way. So, which is why you work with specialists who deal with this day in, day out. Because the mantra I always say is a case is only made as complicated as the person who's dealing with it. So if they know what they're doing and everybody's on side, then you can get them over the line. But yeah, that's the type of thing. There doesn't appear to be very many category 1 straightforward cases at the moment. There always seems to be something, just because of the nature of the clients, their properties, the debts that they've got, etc., etc. So having that clear lines of communication is key, and I'm sure we all work towards that. So that's kind of one of the more complex ones at the moment.
Fab. Thanks, Adam. That seems to be consistent with the first 3 of your examples. Is communication is key. So let's continue that theme throughout the session if we can. Rachael, over to you, please, for a recent difficult case client win.
Recently, we've had a Liaising title, which is their hand-drawn plans. We have to do what's called a plans report, which comes back to compare the old Liaising plans with the OS map. It came back with anomalies, first, which you would never have known by looking at the title. So what's happened is we've got numbers 1 and 3 on a road, on a street, and number 1, the first house, has built a conservatory over what should have been a common path with number 3, which is our client. So we had to do corrective conveyance to basically give number 1 the old shared path and create a new shared path for number 1 and 3. So we had to get a new deed plan which encompassed all this, and to make sure the title, what he legally owned on his own, was all accurate. So it's, although Liaising's cases can take longer, because there's a corrective conveyance involved as well, and you've got to speak to the neighbour, make sure they're happy, there's no money, you know, there's nothing he's trying to claim from the other neighbour, our client. It's just really time consuming, so it adds on an extra few months or even weeks, because you've got to get his solicitor to approve it all, get it signed by them. So it just added extra time onto what was already a Liaising's complicated case. So we got it through at the end, and it was fine, and the client's happy because we've now perfected his title, so to speak. But some lenders might not have been happy about that, but luckily the lender was happy that we'd done the corrective conveyance at the same time. But initially one lender wasn't happy. So, you know, you've got to liaise with the broker, manage the client's expectations, but also see if the lender and their lawyers are happy. So, and we've all got to work together to reach the goal at the end of the day, which is to get the client his money or her money and register a clean title.
I say amazing. Thank you, Rachael. And just for the benefit of all, you know, let's just understand what the Liaising register is. So my understanding is it's the oldest paper register. It's not like that what we'd see in England as sort of the digital land registry. So when you have those instances, you need to essentially update it and make it as available as possible. So if anybody gets any Scottish cases, you know where to go to ask questions and instruct the case. Fabulous.
Agreed.
Thank you, Rachael. Over to Dave from Enact's perspective. So this will be an interesting one to understand, because it's a completely different perspective when we're considering the lender's representation. So Dave, any wins from your perspective, please?
Yeah, absolutely. It is different, and sometimes we're probably in a privileged position of being able to sit back and wait for the other guys on this call to wrestle with some of these more complex issues. To comment on Peter's example with the badly worded transfer clause that effectively caused issues for quite a long time, they were further kind of exacerbated by the customer being very keen initially to revisit with their purchase solicitors and have them solve the situation for them. It wasn't advantageous to do that. The previous solicitors, I think, felt that perhaps they were being questioned and criticised with being revisited, which they weren't. They had dealt with it for their transaction, and this was a completely different transaction with different requirements. So that certainly complicated things. I think the learning from there is to rely on and trust the solicitor who is acting in this transaction to do what needs to be done. From our side, I think the example that I've been dealing with this week is a customer who owned a house that had both a freehold and a leasehold title. The lender in this instance was requiring those titles to be merged, so the house will be registered under just one title. That's something that can often be difficult to achieve, especially when the property has a mortgage on it. So there was plenty of back and forth. In my opinion, all the right steps were taken. The customer solicitor sought approval from their existing mortgage lender, which they weren't able to get. They sought approval from the new mortgage lender to do the merger after completion, which they weren't able to get. And currently, this isn't yet a success story. It's a stalemate where it's not able to go ahead. The learnings I think I want to point out from this is not to be afraid to query unusual special conditions or requirements that are raised on a case. They're usually absolutely genuine. There's very good reasons for them, but not every mortgage lender and not every product, even from the same lender, has the same criteria or the same requirements. So it's always a good idea if you see something that appears to be unusual, to discuss it initially with the customer solicitor, find out their opinion, whether they think that can be resolved, as part of the normal transaction, or whether it may have some issues. And potentially then to query it with the lenders themselves and just say this might be difficult. Are there other options? Are there other products where this might not be required that would still suit the customer's needs? I think after a number of months, that's probably what's going to happen on this one. They will have to find a different product to proceed with. It's just unfortunate for their experience that that didn't happen earlier, I think.
Amazing. Thank you, Dave. And again, to highlight, consistent with all of these, and I'm going to give you a case just now as well, which we've had on the desk recently at AdviseWise. It's communication. It's capturing as much information up front on your fact find to facilitate this. It's not that lenders and solicitors are trying to, catch you out. It's they're trying to do best by the client, right? They're trying to make sure that we have excellent customer outcomes. So I've got one that was supplied by our guys that run our help desk. And if this is somebody's case on the call and I butcher it, then please do jump in and add more context to it, please. But we had one where there was a husband and wife on the deeds, as well as the wife's sister. So you've got 3 people residing in the property and 3 people on the deeds. Now, straight away, any advisor that's operating in this space will know that lenders will generally only allow a max of 2 people on the deeds. All reside in the property. They've already done quite a lot of the donkey work. So they've arranged for Mr. to come off the deeds. So it's going to be wife and sister that remain. And they've already gone through the process of getting independent legal advice. So that's number one. That's a requirement, to make sure that they are doing that and knowing what they're doing and the risks associated with it, with Mr. coming off. All 3 of them will continue to live in the property. So then you've also got a requirement of an occupancy waiver, which has since been sorted as well. As I say, communication is key here. So most lenders will want this sorting prior to application. There's lots of reasons for doing this and taking people off titles, but they'll generally want to separate themselves from that and have this done prior to application. Most will only consider 2 on the deeds, certainly for lifetime mortgages. And it can also take a while to take people off the deeds. So when we're talking about a rate market that changes, fluctuates, and potentially increasing like it is over the next week or so, it's important to consider that and manage expectations. As we know, anyone over the age 17 requires an occupancy waiver. And in some instances, it can cost significantly more when you start to do all this extra legal work, which we'll come on to actually over the next few discussion points, is the use of a specialist solicitor, and perhaps dive down into some of the costs associated with it. So it's great to see a lot of vanilla. I think one of the guys referred to it as a type 1 case earlier. But at the moment, with the demographic of the market, with the types of clients that are coming through that we're transacting with, we often find they're a little bit more messy and require additional work. So when you're managing clients' expectations on the costs, don't just see the headline cost as the cost to your client, because if there's a transfer, a divorce or something like that, it can often add up. And rightly so, because there's lots more legal work to take into consideration, right? So that kind of segues us on to the use of a specialist solicitor. And there's been themes around it so far already dropped in, being able to complete in a much quicker time. So I'd be keen to know from the speakers, what's your typical time frame, offer to completion? I'd be keen to know, what specialisms you guys focus in on, which we've already dropped some of them throughout the introductions as well. And then obviously to counteract that from David's perspective, what's it like working with a specialist compared to a non-specialist? Correct me if I'm wrong, guys, but I still think 50% of ER transactions are conducted by non-specialist solicitors or thereabouts. What impact does that have on the wider market? So yeah, just to open up that discussion a little bit. So the overriding question is the benefits of using a specialist solicitor, and I'd like to get a few different perspectives on those benefits as well. So who wants to jump in on that one?
I'll go first, Dan.
Thanks,
so yeah, turnaround times are often asked, how quick we can get something over the line, or what advisors should be telling clients in terms of signposting and expectation management. I suppose to provide a bit of balance, the cases that are relatively clean, so the type 1s or the files that don't really have too much additional work associated with them, they are flying through. Dave and the guys at Enact and the same over at Connect. So if you can find us a relatively clean case with a motivated client, you'd probably be completing in 2 to 3 weeks from offer, possibly even quicker, depending on the makeup of the file. As you move away from the non-standard stuff and into things where we need to do some additional work, they can be quite simple things like an occupier waiver, or or dealing with a transfer on or a shortfall, but they could also be solar panel lease variations, weird trust issues, title entries that take forever to get sorted. Average turnaround times for those with us are about 32 days from offer to completion. So certainly double the clean stuff. And you've got a write-off range in there, because again, a case with an occupier waiver that just needs that witnessed by somebody independent of the transaction is probably going to be down at the 15-16 day turnaround time, and something that requires a solar panel lease variation with some solar panel company that's no longer in business is going to take months and months and months. So it's really important, particularly from not a heightening client expectations too quickly, just for us to, or any of the specialist listers, to have a look at the file, compare really what's hot and what's not at the moment, and then we can probably give you a relatively good guide to how long we think that's going to take to get over the line. With the caveat being, we still need a motivated client. We still want somebody there to be able to meet our solicitor for their home visit, do all the things we ask them to do, interact with us, and supply information. But yeah, to provide some balance, if you can find a clean case, it'll zip through no problems, and you have a very happy customer.
Thank you, Matt. Very good answer there. Thank you very much. And that's one of the questions actually that you linked onto there. How what's the average turnaround times? When we sent out the mailer to join this webinar, we asked you delegates for some questions. So I'm just linking into some of those questions now. So yeah, one of the questions was, what's the average turnaround time? So it depends on the case, depends how motivated the client is, and any of the extra legal work. How can advisors help to complete that quicker? So obviously it'd be easy for us to say enhance the communication and capture information, but is there anything from any of the other speakers that can support that in terms of what activities can people do to do things quicker?
Yeah, I'll jump in on this one.
Yeah.
Just to expand on Matt's comments, as he was talking, I checked some of our internal data. For the past 12 months, cases that have a specialist solicitor on the other side from Enact complete on average 9 days quicker than non-specialist cases. So much of that will be the more complex ones where significant gains will be made, but it really does show that it motors the files through when you have a specialist on the other side. In terms of getting cases through as quick as possible, we've touched on some of the complex files already. They are all about communication. They are all about front loading and putting everything on the table as soon as possible, so that the right route can be taken to achieve the completion. But there's huge wins to be made on the simple vanilla clean cases as well, simply by making sure that things are accurate. So full names provided on the application, including middle names, all the account numbers for any existing debt provided from day one. Occupiers warned in advance that they are likely to have to sign a document and probably get some independent legal advice of their own. All these kind of steps will make a big difference, so that when we're raising that issue, it isn't new. It isn't something that has to be started afresh. It's kind of in place straight away. The account numbers for the redemption statements, that is also going to be a massive win when it comes to potential shortfalls. So if all the existing debt is known and considered earlier, proper plans can be put in place for payments of those shortfalls, monies being in place and ready, and proof of the source of those monies as well, which can be tricky for some customers.
Great, thanks for that, Dave. And I think you've kind of dived into some of the areas of the next question, which was the common reasons for delays, right? So we've outlined that perhaps name discrepancies, not having the correct information on offer or on application, even to the lender, and shortfalls been a big one. And that's one I wanted to open up the discussion in and around shortfalls. Why is that? We're seeing more and more plans come through. We talked about innovation earlier with the PTLM style products where income and affordability is assessed. We're seeing some of the hybrid style products where optional payments can be made for a discount, so the interest servicing style plans that we're seeing. And I can imagine shortfalls is becoming more and more common, and it's also a significant cause for delay. You can't physically complete if you haven't got enough money to clear that mortgage, or if that redemption statement wasn't captured in time and there wasn't a consideration for that redemption to improve or not improve necessarily, increase. So shortfalls, does anybody want to add any more sort of meat to that bone in your experience?
I can jump in if you want, Dan. I mean, yeah, we do see shortfalls a lot, especially at the moment with LTVs being so tight. Obviously, customers trying to repay a mortgage, for example, or trying to raise money for something else, but this charges. So there's a couple of ways you can identify earlier. One is we can ask any of us to download the title so we can see what's on there, see what the registered charges are. We also find as well, because not everybody does a credit check on a client pre-application, because generally speaking, it doesn't really come into play with equity release. On a normal mortgage, residential mortgage, you do a credit file because you've got to get through a credit check and you'd see everything on there. And often things might crop up that the customer may not disclose, may not have forgotten about or known about. People have things on the title or things that they've forgotten about that has to be, as part of the loan offer, has to be repaid. That then can create a shortfall. I guess we'll all have different limits, but once there's a shortfall, then money laundering requirements come in, so we have to check that. We were going through a bank statement yesterday where the lender had identified, I think it was 60 transactions they want to check in. So that is a solicitor going through the client, going through the bank statement, saying, right, where is this from? Where's that from? Who is this to? Et cetera, et cetera. So it can really, really lengthen the process. So shortfalls, do delay, and sometimes shortfalls can even appear literally days before completion. And then everybody's running around trying to get that sorted out. So there is ways to identify them early on. Asking the client what of the, as part of the fact find, that would be obvious anyway, but we can check the title for you pre-instruction, like Peter, Matt and Rachel no doubt can see what's on there, because obviously it's first charge lending, so that needs to be repaid. So that's a known shortfall. And then if the client, if we can request red stats on I know Dave with Enact, they do the red stats, but we've got access to LMS and lender exchange, so we can request red stats on mortgages to get a feel, or other things on the credit file to feel what that red stat looks like, because a mortgage balance may say A, but the red stat says B because it's an ERC or some other charge in there which actually may bump up the lending required. So again, it's just about being upfront, knowing everything early doors, what needs to be repaid, what's the redemption statement going to look like, so what's the actual repayment figure look like, what are the fees going to look like up front, so you can factor that into your advice. We can all give you an indication of the more information we know up front, the more we know it's going to cost. So again, advisors can factor that into the advice, so then there's not a shortfall at the end when sometimes it's shortfall that they can't pay the fees, because then we as a firm, we have to take a view on that as well. So yeah, again, it's about getting the information up front and utilizing what we can find out early on.
Yeah, awesome. Thank you.
Can I just
very
add
much.
in there about shortfalls?
Yep.
I've seen recently that with some brokers saying that there's going to be a gift from another family member to cover the shortfall. That's quite scary. Not all lenders will accept that, depending on the value of the gift. So, and again, you have to do still anti-money laundering checks on the person giving the gift, so to speak. So if the broker knows that it's going to be a gift, it's like, how much is the gift? Check with the lender that they're happy with that, and will they need a gifted deposit letter? And then obviously take it from there. But don't just assume that if it's $5 grand or 10 grand that the lender, solicitors or us would accept that gift, so to speak.
Yeah, and I know sometimes from an advisor perspective, it can appear like you're trying to be caught out. It's not, right? So the specialist solicitors, from a client's perspective, they're there acting on behalf of the client to protect the client, to make sure that everything's watertight, and rightly so. And then from the lender's representation, they're there to make sure they've got suitable security, and it meets their criteria as such. So work with the guys. It's there and it's designed to protect everybody involved, including yourself as well, right? So you don't want any future complaints coming back on you or your business. And kind of linking into that as well, and on open communication. I know, Rachel, we mentioned it earlier when we were discussing before the session start, was in and around the pipeline, in and around customers perhaps that aren't proceeding anymore, and you find out further down the line after perhaps a couple of communications with a client, and it's unnecessary. So you perhaps reaching out to clients to progress things, and it's unnecessary, and you weren't told it's closed. So how can advisors, I guess, tell you what's the best way? Just tell you as soon as possible.
Yeah, exactly. Because I'm having to go back to, print off a spreadsheet or, from data from our CRM system to see what's still live. And some of them are to last year, and you think, is there no offer coming through? What's happening? So I suppose it's them working with us to say, this is now fallen through, the client's changed their mind, they're not proceeding. I've got one client who's shopping around to get the best deal. So I've literally got 3 brokers, 3 different lenders, and he's not decided which one to go with yet. And it's ridiculous. So surely that broker must know early on if that client's kind of humming and hawing, not proceeding with the offer that they've had.
Yeah,
it's
and
difficult.
You do get a lot of that in a price sensitive or a perceived high rate environment. You get customers that are perhaps shopping around, even with advisors. I see it all the time that they're speaking to a couple of different advisors where they can get a better, cheaper fee, potentially better rates, and that's hard to manage. But I just say keep your professional relationships there and keep the communication lines open. That's really, really important. Just moving on to one question we had from the registration from you delegates as well. We have covered this before, but Peter, one perhaps for you to dive into, because I know you love trusts and you love to dive into the detail there. I'm seeing laughs from everyone around just to put you on the spot. But is what's the process in and around a trust? What are the considerations? From my perspective, lenders are not keen. They need a clean title. But yeah, any more meat to that bone you can put on, please, mate.
Yeah, we can have a beard meets food sort of discussion on something. No one watches that on YouTube. Fantastic. Yeah, trust. I get asked daily of 2 things. Firstly, is I was asked just yesterday, can trustees take out an equity release scheme? So a loan to trustees, as it were, which the advisor quite rightly said, Peter, I'm 99% certain the answer is going to be no, and it is no. Being as old and grey as I am, there was only ever one lender. It wasn't equity release. So NatWest used to do a loan to trustees. So that's obviously a no-no. I get lots of emails, as you all know, because I bore you all to death about it, saying, Peter, can we break a trust? And I'll always reply back saying, don't know, send me the trust. So I think the first and foremost is, usually a trust will be evidence on the deeds, either by the tenants in common restriction in section B, or there might be specific wording on there saying that there was a trust in place, or you'll see one of the co-owners, maybe a trust company or some third party or a family member. I think if it's a will trust, again, it very much depends on the specific wording. Us solicitors are brilliant at our wordings, and 2 or 3 words in a slightly different place can mean it's unbreakable as opposed to breakable. I think the things to bear in mind are, within a will trust, and again, we will, as the lawyers here, we will always comment on it for you. So we're not expecting you to have that legal knowledge just get and over to us. But things to watch out for is if the ultimate beneficiary is a charity, it's always going to be a no to breaking that trust, because charities aren't allowed to agree to breaking the trust because it's against their charitable purposes. If there's stepchildren involved, and I have been proved wrong many times, and more I'm being proved wrong, that stepchildren are always happy, to help out their step parent, but often with stepchildren, they're not happy for a trust to be broken, because they would say, well, Dad set up the trust to protect half the house for us, but generally speaking, they can be broken. The trickier ones to break are the old school nil rate bound discretionary will trusts, which are no longer, or they're redundant for inheritance tax purposes. Clients will often have forgotten that they weren't there, or that they'd set these things up, because they'll phone the solicitor on first death, and the solicitor will have forgotten to check and say, oh, it's all fine, it goes to you, and then we're embroiled in kind of breaking it. But we will always give you that summary, I think. So first and foremost, get us a copy of the will trust. We will let you know whether it's been broken. The annoying thing now about these will trusts is they have to be registered before we can then break them. So that always adds costs and a bit, not necessarily a long time delay, but you have to register them with the revenue just to then break them. Timing wise, as my peers were saying, if you've got a supportive family, there's no reason it will cause any significant delay. We can get the documents drafted up within 5 to 10 days, out and back. And we know how demanding Dave is and what his requirements are to satisfy him. So that's not an issue. I think it's really the main cause of concern for me is always who are the ultimate beneficiaries. Are they going to be happy to give up that half of the property?
Amazing. Thank you. Sorry, putting you on the spot there. That one wasn't prepared for everyone. That came through on the chat to me directly. But no, really good and concise answer. And just whilst Peter was speaking there, I was just looking at our internal. So the Mortgage Club at AdviceWise has a criteria matrix that we can confer. And, we often have advisors ring up to ask these unique, weird and wonderful criteria questions. And I can see the column and the row for trust, and it just says no. Find out more information. So the salient point there is bring more information than just will you accept a trust. But if anybody's interested in getting that extra level of support, you can always reach out to our free to use Mortgage Club. So mortgageclub@advisewise.com. We've got a live chat. We've got the phone lines that are open 9 to 5. And that can be a great starting point. First of all, to understand which lenders might consider it. And then obviously, should you want to confer to anything more technical, I'm sure all of the speakers on the call would welcome that query, even prior to instruction, to help get the best customer outcomes. They're always here to add value and support you in your advising journey, and obviously support your clients. But we're just coming round to the end. I just want to open it up to any live queries or cases. I've gone through all the ones that came through on registration. We've gone through some of our predetermined queries that we wanted to discuss, but just from any of the delegates on the call today, feel free to unmute yourself if you want the opportunity to quickly ask the team some of your recent cases. Perhaps you've got something on your desk that's difficult, or perhaps you've got some best practice to share with everybody else on the call. Not often do you get these guys all on a call at once, so take the advantage, take the opportunity whilst it's there. Does anybody want to unmute? If not, if we're too shy to do so, we'll move on. Jane,
Can I ask, when you're doing a redemption, who actually does the final redemption with the lender? Is it the lender solicitor or is it the client solicitor?
It's normally the lender solicitors that deal with paying off the mortgage, and they normally deal with ordering the redemption, unless it's Connect. So the borrower's solicitors order the redemption, but Connect will pay it off.
Awesome. Good question. And nice to see you, Jane. I've not seen you on these sessions for a while. Awesome. Well, that's a good question to finish off the session. I'm not seeing anybody else on mute, but please do interrupt me if you do. As a point of closing up the session and thanking everybody, I just want to take a second to thank the speakers for joining the call and giving up their time in their busy schedules to add value. Obviously, this session is going to be recorded, so you can watch it back retrospectively and share it. And I'd encourage you to do so. Thank you, all the delegates, for keeping to the housekeeping rules and popping the questions over on registration as well. That's been really helpful for this session. Again, the recording, we will email you over the next 24 hours or so with a link to the recording with your CPD certificates. Get that tracked. And if you want any more information from me, the delegates will share all of their contact details in the follow-up. Similarly with AdviceWise, if you want to know how to use the tools and resources better, the sourcing better, take advantage of the Mortgage Club and much more, then do book a demo in with us directly. There'll be CTAs on the follow-up to do that too. But that's everything from me. Thank you all for your time this morning. I'm going to hang around on the call just to see everything close up. But yeah, have a great Wednesday, rest of the week, and we'll see you all again soon.